So I'm going to go ahead and call this work session to order. So the purpose of this work session is to review the special land use permits and the SLUPs and putting modifications on them. We're going to start this by having a presentation by Dean, and then we're going to have a discussion on the process. Particularly, historically, I believe it's the Assembly has put on conditions pertaining to price or those other types of modifications on the license, and those then go to the Alcohol Marijuana Control Board for approval. Now, just based on the recent licenses and processes, particularly with mom and pops, in and out, and then now the third one in Midtown, the Cars Safeway license, the Oak and Keg, at their new location. We are looking at if we can do the same process on the SLUPs and make these types of modifications on the SLUPs. So that's going to be a discussion that we have. With that, we'll do introductions, and then I'll turn it over to Dean.
Gretchen Wemhoff.
Felix Rivera.
Austin Davidson.
Dean Gates,
Mandy Honest, Clerk's Office.
Francis McLaughlin, Current Planning.
All right. And then I just want to state for the record that Suzanne and Forrest were unable to attend today. And then is there anyone on the phone? Okay. I'll turn it over to Dean.
Thank you, Mr. Chair, Mr. Vice Chair. So yes, thanks for the introduction. I think you explained out well on how we ended up and why we're doing this work session today. So I think that we will just jump into our PowerPoint presentation. I worked on this with the Municipal Clerk's Office with Ms. Honest.
Tell him to speak up.
Oh, sure. Please let me know anytime if I need to speak up or repeat anything. So, I understand we're also doing the Facebook Live broadcast, so I guess I need to speak up for that as well. All right. So, I thought we would first start just the general concepts of a special land use permit for alcohol, what it is and when it's needed and so forth. And you're probably familiar with a lot of that already. You've processed a lot of them in your time on the assembly, so we won't spend a lot of time on this part. But we got a sort of a necessary little background. So what are they? Per code, new code and old code. Old code still applies to our downtown districts. It's going to apply until we have some new code that applies to downtown districts. So I will refer to both from time to time, but we mostly will be referring to new code and its improved and efficient process. So any use that involves the retail sale of alcoholic beverages requires a permit, SOP approved by the Assembly or Director. For a restaurant eating place liquor license, beer and wine licenses, when beer and wine is sold for consumption on premises only, those can be approved by the Director of the Planning Department, so the Assembly doesn't see those at all. The special land use permit for all other liquor license types are approved by the Assembly. I thought I might note this is retail sales, so the production, manufacturing, like a brewery or distillery, that's not covered by the special land use permit, but that does generally have conditional use permits required for those as well. But we're not going into those types of uses, just retail sales, right, for consumption on or off premises. So when do you need one? The procedure we've seen and are familiar with is when the liquor license application is received, when someone wants to open one right or transfer ownership or move to a new site. They need to apply to the ABC board, the state of Alaska. So once received, they send that to the clerk's office, and the clerk's office is honest and turns this to the planning department and requests certification of the proposed location if it has a valid special land use permit. So if it does have one, oh, I'm sorry, I'm getting ahead of myself. Special land use permits are basically a legal entitlement. You know, this is a person's real property, and they attach to the property. It becomes a property right So it's important that, and the reason we have all these detailed procedures is we afford these property owners with the special land use permit the due process that they're entitled to continue operating, using their land and their property the way that they wanted to in compliance with the law. So due process is very important. That's why I have so many details. So, sure, anytime.
Thanks, Dean. Felix might have said this and maybe I missed it, but when do you need to do one of these? Do you need to do it for every alcohol permit or just if there's a special use, like a conditional use?
Every alcohol permit. So,
Okay.
I used to hearing conditional use permits.
Yeah.
So some years ago, when they did the Title 21 rewrite, we came up with this phrase, special land use permit for alcohol. It's pretty much synonymous with the conditional use permit and conditional use permit needed for an alcohol use.
So it's
there's no
not-
real distinction other than the name.
Got it. So it's not special in the sense of getting an alcohol permit. Every single alcohol permit is a special land use. Okay, got it. Thank you.
Yes, exactly.
And
Well,
no
so
problem.
that's
Thank you,
exactly.
Ms. Davidson.
I
Just
guess you could say
for the
it.
record, Mr. Peterson has joined us.
Thank you, Dean.
Sure. So they're, like I said, attached to the real property, it becomes property right to continue doing so. So it simply is going to affect that property right, they need due process. But there are codes, some certain situations where the special land use permit will expire by operation of law, and we've listed those here. You've probably seen those before, when there's a transfer and there's no new application for the new owner or within 120 days. And if the use has been discontinued and vacant for at least a year, or if the business becomes very different. So the review process for special land use permits for alcohol. First, as we said, we get a liquor license application, send to planning, they verify if there is or isn't a special land use permit already. So if there's not one, we've got that left-hand column. Then we need that owner, developer, or applicant needs to apply for a new special land use permit for alcohol. So we usually see those together with the resolution for protesting the liquor license plus a special land use permit if they didn't have one previously. So we've got that review process there, and that's those reports. If there's already a special land use permit, but perhaps the liquor license application is for transfer of ownership, but not changing sites or anything, that doesn't affect anything that's happening on the property, use of the property. Dean is selling my liquor license to Felix, same site, same bar, same use. Nothing changes. The special land use permit still is in effect. It attaches to the land, not to Dean. So we can transfer that. Again, though, it's a little more, I guess, smoother, faster process. You don't have to apply for the special land use permit. Just consider the liquor license process. So.
I actually have a question, Mr. Gates, and I just, for the record, Mr. Weddleton has joined us. So the location, the new car Safeway Oak and K, part of that license was needing the slip for that. So the slip is tied to a specific physical location. Because I remember they used to have an open keg there, but because it's not right, so because it's not the same location, they have to get a new slot. Got it. Okay, thank you.
Well, I'm not really prepared to talk about any specific application, but generally speaking, I know the sites in the area they're talking about. The ABC control board, they require a designated premises diagram that would cover just the open cake where it used to be. So now it's on the whole other side of the Mojave, and they would need to do a whole new special land use permit for that. So and I think that I had saw that Mr. McLaughlin agreed with that. Correct.
Thank you.
Yeah, that one, the license expired, so they just had to start fresh. But I think it's a different parcel of land. I think there's a there's a lot line that goes right down through the middle. But it's a whole new, store. So we would say that they need to apply for a new special land use permit for alcohol to get approval from the assembly.
Okay, thank you, Mr. McLaughlin. Mr. Trainee.
Plus, they'd also transfer the old license to a different location.
Yeah.
So to in effect the license didn't exist there.
Right.
I would come in for a new license location.
Right. Yeah.
Thank you, Mr. Tran.
That's true, both the new license and the new special land use permit.
All right, thank you, Mr.
Sure.
Tracy. You can continue.
So that's the review process. Generally, we get into a little more detail. So what's the Assembly's relationship to a special land use permit? I guess the code splits this up into three sort of approaches. One is new applications, except for starting places. And then when there's already one in place, but there's major modifications to a special land use permit. Generally, those come from the owner of the permit already who wants to expand or do something different, maybe to modify their existing permit. And now number three, and that's really what the catalyst we're calling our work session, when the Assembly at its discretion wants to modify conditions of a special land use permit. This has been in code for a while, since the time when I rewrite, and actually in old code as well, I believe. And I just don't recall myself seeing the Assembly-initiated modification of conditions actually being used, because I guess we've been using the liquor license protest and requesting the AMC board impose conditions with the state liquor license. So number three is the Assembly's authority exclusively for land use and a special land use permit, separate from the state's liquor license. And what we're talking about today is, well, let's not forget about, but instead of pursuing a liquor license protest, we're asking the APC board to attach conditions that we want for a certain operator or business to their liquor license. Let's look at modifying conditions for the special land use permit, so we don't need to go through the ABC board and wait for them to do what they do or have them deny, what they simply requested, because we didn't have enough information or facts to warrant or to get over the arbitrary, capricious, and unreasonable standard of review that they have. So, also within their short time frame, which I'll mention again later. Well, modifying conditions, number three for the Assembly. I've been here, I'm sorry, generally, not just number three, but generally any time that the Assembly is looking at conditions for special land use permit process, the planning department reviews, and they review under these two code sections. There's approval criteria in 21.024.040C, which is general conditional use approval criteria, so any conditional use, and they've got a list. I've created this cheat sheet that lists those. That's in one of your handouts here. It's got a draft watermark across it. But I basically thought that this lists on the back side all of the approval criteria of 21.024.040C. This memorandum is similar to one I passed out when we had a rezoning in front of the Assembly not long ago. And I thought it's helpful to be sort of a cheat sheet for the Assembly members to have on hand next to you. Instead of looking for code and where it is, or through the stock packet and what's the approval criteria, whether it's maybe testimony or looking through pages of the packet, to have all the criteria in one sheet next to you. So if this is helpful, I will try to continue doing this for things like rezonings or special land use permits and things like that. So, and then there's some standards in 21.024.040C that we get to later. I posted the code section about the Assembly's action as 21.024.040C4, and that sentence in the middle, after holding a public hearing, the Assembly shall approve conditionally or deny the application. You've got those three options, right? In considering which action, the Assembly shall apply the criteria set forth in this title, Title 21 for conditional uses in 21.024.040D. So that's why I wanted to make sure I emphasize that. That's the criteria used. There's like 9 bits of approved criteria there for consideration. So we have in the past we've seen a lot of these resolutions, and generally we have a template for Assembly resolutions. We have a handout here that has these 7 boilerplate conditions, which are always included. They're part of the template that we start out with. And the planning department developed this template some years ago, and they had included these boilerplate conditions that are always there on the template when they start out with any new application, and they will be there. And then it's the additional, I've summarized them here, and they're in your handout, number 1 through 7. They're basically making sure that this zoning action's recorded in the recorder's office, so it's part of the official state property records. And then conform to plans that an applicant submitted, except they can change their operation hours as long as they're compliance with Title 10 and state law. And really the type and number just identifies who it is that sales that are 7 days a week, which is sort of just emphasizing what's already in code. And the server training maintain card, which is also a legal requirement, and that the use must comply with any law that's applicable to them. The owner or licensee is responsible for that legal compliance, and that they must maintain the resolution and the list of conditions in a visible place on the premises. So those are all boilerplate conditions. So, I mean, that's the boring stuff. Here's what the exciting subject that we go for today is adding extra conditions to these standard conditions. So we can add them to a new special land use permit resolution. We've seen that from time to time. This is special terms or conditions in public interest and consistent with code. There are in addition to these boilerplate ones. And now that second bullet, adding to a previously approved special land use permit, and this is when we want to modify special land use permit and add extra conditions. And that's the process we're mostly focused on here. And they can only do that, they simply can only do that if there are public safety concerns or negative impacts on the surrounding properties. Then that justifies adding modifying special land use permit conditions. And of course the due process requirements, notice of the action given in the public hearing must be held, and their opportunity to respond and defend their existing conditions. So I, at this point, wanted to sort of compare what we're doing that's different. And I mean, you understand about what really are the substantive differences in going in the procedure for adding conditions to a license or special land use permit. So number one, it's an ABC board decision or assembly decision, right? I kind of touched on that. Under a liquor license, we usually see these opportunities to add conditions during the biannual renewals of the license. And at that time, you have a 60-day window from when we receive notice from the ABC board for the community councils to, or actually, I shouldn't even say that. We have in October notice to community councils that renewals are coming out, get ready. And then we receive actual notice from the ABC board that we have a renewal application. And maybe somebody decided they're not renewing and there's legally a lapse, right? So we get actual renewal applications. And we got that 60-day window then to get our resolutions for the body and whatever conditions we want to add with justifications for them, some factual basis so that they're not just arbitrary and so forth. And then we send that back to the ABC board within that 60-day window, maybe with a conditional test that says finish up. If we saw recently that that didn't work when the assembly didn't describe why, we needed a little more time. So, and one big difference, well, I guess going to the special land use permit. Number two, the assembly can consider these any time, right? Which we have a basis, but any time there's no like 2-year renewal process and so forth. So if you see a problem up later, or think we need to modify these conditions, there's no time frame for when you can start and do it. This is the assembly's authority. You can do it when you think it needs to be done. So number three, the timeline. Looking at coders actually, and I mean, I invite the planning department to chime in when you receive an application or when the assembly initiates an application. When does it have to be finished? We have a 60-day window for the legal license process. The special land use process, I only saw a code generally in the application that's not completed within a year. You need to submit a new application. Is there any other like time frame? I mean, we do the work, we do it diligently, we try to get it done. But I didn't see upper limit other than 1 year. So,
no, that's correct. So when an application is submitted to the planning department, it's approximately 45 days until it makes it to the assembly for a public hearing decision. And in that time, we do notification to all the surrounding properties about the public hearing, and we send the application to the community council, and to like the municipal traffic engineer and different reviewing agencies, and the planning department compiles all of that information in one packet to send to you.
So I have a question from Ms. Quigley.
Francis, so we have a year to do it, but since the state wanted 60 days, we do it basically on their timeline so that we're not holding them up, or what's the 45 days and how does that relate?
No, the year is sort of distracting us from what the issue is somebody comes to the counter and submits an application that the planning department processes to you. And again, that takes about 45 days. 1 year, I think he's referring to that we have a section in code that if an application comes in, because if it comes in incomplete and they don't make payment, then we're supposed to toss it after a year. I think maybe that's what, and that's very rarely kind of, we have sort of some old files that sort of stuck around for a year that we have to purge at the, I think that's probably what he was referring to.
Yes, that is right.
So
Because I didn't see any other specified time frame, but actually, for the comparison, I think I recall, I can't point to the code provision right now, for a restaurant eating place, special land use permit, those are administratively approved by the planning department director. I think there was a 45-day frame in there where it says the planning department process or respond to the applicant within 45 days. But we don't have that for the special land use permit for the other uses for the assembly approval.
That's right. We actually have a time limit which we have to make a decision by. From the time we accept the application, the decision must be made within 60 days, but we do it in 45. But we just have to be on our toes that we couldn't sort of mess around with the application and lose that window. But that, anyway, so that's one of the troubling things about regulations like that have a time limit on when an action has to happen, because there could be that the applicant wanted to postpone or something like that. But anyway, it's generally not an issue.
And that deadline is the case whether you have to approve it administratively within the planning department if it's the beer and wine, or if you bring it to somebody, try to do it on the same timeline so as to not slow these guys down.
We publish the dates. We try and process things quickly because businesses generally want to have their approvals as quickly as possible. And they don't want to be caught between two different sets of regulations, the state and their process and the municipal process. It's kind of nice for the applicant, actually. They process concurrently.
And part of it with the 60-day deadline, a lot of the license reviews that you'll see will protest pending completion of the special land use process. So to keep our option to protest within that 60-day window constraint, we'll do that, but it allows the applicant to continue their process with their special land use permit application. And then the assembly has granted the clerk's office the authority to lift that conditional protest once the planning department says that they've approved it if it's a restaurant eating place, or once you see the special land use permit AR come before you for that license and that location, and then we see that you've passed it and it gets lifted.
And then just one more follow-up, and Mr. Webster's question too. I was just going to ask, if it's a good segue, sort of how the planning department works with you, because we hear primarily from you, Mandy, on these things, but there's also this planning department element. Do we just hear from you when the assembly's involved, and that's why, or how do you guys work together?
So the license review gathers information from multiple reviewing departments. The planning department is included. So when we get notice that there is not a valid special land use permit, that's kind of considered one of our reasons to protest the license.
Okay.
So that's on the document that we present to the assembly as a conditional protest. So you communicate with the planning department when they submit the AR for the special land use permit later on. They're not always on the agenda at the same time. And so as Dean was talking about those 9 specifications, you see those as the planning department's staff report.
Okay.
So they list that out for your convenience to say, you've delegated that review to that department. And so they list how those have been met in their review.
I could add that there's really good communication between the clerk's office and the planning department, because as many as a dozen times a day, an alcohol license is up for a restaurant designation permit, transfer of ownership or controlling interest, transfer of location. There are all kinds of different, change of premise diagram extension, which is their floor plan change. So all of the alcohol licenses within the municipality of Anchorage, and there are many, 600 or something? Yeah, and so all the new ones, all the existing ones, all that stuff, it's a very active portfolio. There's good communication between the clerk's office and the planning department. And it's very active because there's restaurants going in and out of business all the time. And so many times a day, I'm reviewing information that the clerk's office is sending to the planning department. And I think, did you mention, Mandy, that you send it to several other agencies as well? Yeah.
Thank you so much.
Thank you, Ms. Clinton. Mr. Peterson, then Mr. Wilson.
Thank you, Mr. Chairman. And so there's talk that they may possibly be a change in the notice requirement from 21 days to 31 days. And would that have any, or what effect would that have on our timeline, or would it have any
That's your notice.
Oh, I know what you, we recently were at a community and economic development committee meeting talking about what are the notice requirements. Well, things are working fine. I think with the code, the regulations and the notice requirements that we currently have. If the notice requirement were increased by 10 days, then that would change the timeline for all the little activities that we do, because we would have to send notice out to the public sooner.
Right.
I'm not sure if that would delay the applicant, add time to the applicant, or if we could work within that to just send the notice out sooner. Because as we talked about, there's 45 days built into it, so maybe we could send it out sooner. But I hesitate to offer that up because our staff. I mean, we have essentially one administrative person that's processing tons of applications, and she'd be furious with me if I said that she could do it faster or something. I'm just being honest with you.
Right, well, we did talk about it for a couple of minutes at the Community and Economic Development Committee meeting a week ago, and it was brought up again last night at the Northeast Community Council meeting, so. Thank you.
Thank you, Mr. Peterson. Mr. Wilson.
I had one question.
If I could add, Mr. Chair, I wanted to add just one more statement from the process we've been using the liquor license at protest resolution, and sometimes we conditionally protest until special land use permit is completed. You wouldn't really see any difference, I think. We'd still do a conditional protest until that's completed, whether it's 21 days, 30 days, or however long. It's do conditional protest until that special land use permit process is done. So I don't think you would see anything different in terms of our current procedures for a protest resolution.
Thank you. Go ahead, Mr. Wilson.
On that 31-day notice, you're not, community councils, there's 21 days it might hit when they're not meeting. That's why they want the 31. But with liquor licenses, you're sending out, like you said, you've seen it way prior. You know these are coming up, so they have months notice, don't they?
For the liquor license applications, as soon as we receive a notice of a complete application from the state, we send notice to the community council. So the 60-day window that we get to do the review and put it before the assembly, the community council gets notice of that at the same time we do. But I do know that the state sends notice to community councils as well.
And that's separate from the planning department's notice. So that's why I shook my head that Mandy's notice is separate. It's related to the license. Planning department is only primarily dealing with the conditional use permit for alcohol or a special land use permit for alcohol, depending on what part of town you're in.
I doubt the community councils know that distinction or care. They just want to know. And I guess I'm thinking marijuana. Marijuana, you know, way early.
Right.
I think,
Mr. Gates, did you have something to add?
yes, if I may.
Yeah.
I think what you might be thinking of is the renewal process. So when it's a new application, and the new license for a new site, it would happen exactly like they said. But the renewal process, we have another additional notice in October. We already know who has a current license. We already know that they're going to be renewed January 1. the code says that in October, notify the community councils of all the current licenses in their community council boundaries that are coming up for renewal. So that's that way advance notice they get when there's renewals coming up and which licenses are valid. But then when the application actually comes in, they could add the same notice as they do for a new license or transfer of location.
So the notice goes out actually in August, and then October is the deadline that community councils have to get back to the clerk's office if they would like to request a public hearing on any renewal.
That was
That'd be so
yeah.
helpful.
Thanks.
Sure.
You know, here it says one of the things for must include a list of all licenses within 1,000 feet. Why do we care? Someone
Where are you, John?
on this one.
So, this draft watermarks, because it's my memo, some things I summarized, that part about 1,000 feet, that's just in code.
It relates to the constant over-concentration of alcohol in one area.
Have we ever acted on that? With downtown where you've got them sharing walls?
It's been a topic of discussion. Is there an over-concentration of alcohol in certain areas? Downtown maybe isn't a great example because you think of your central business district as maybe having lots of bars and restaurants and an active nightlife and that. But maybe in a different neighborhood, then you could be concerned about too many package stores on one street or too many bars on one street. And you might use that as a justification to say, we don't need another alcohol license in this area. It has, because these types of land use permits have, potentially have, impacts on surrounding businesses and residences and parks.
And then, I don't know if you were bringing up, but we've been talking about area restrictions, so this speaks to that. So what would you do if there was a large area with 20 licenses identified for special restriction? Are you prepared for that potential scenario?
You could.
Every package store in Midtown, all of a sudden we're going to attach restrictions to their slot.
Well, you mean?
I know we talked about and had the proposal for area of restrictions on all licensees, and I think there's some serious legal concerns
Yeah.
with proceeding with that proposal, mostly because, and we mentioned it before at committee meetings, you involve all licensees within one area, where some are, that have been good operators, they have different operation than others, and have been causing problems, still contributing to social, economic ills that gave us concerns in the first place to draw these boundaries for an area restriction. So I think that there might be some equal protection and due process concerns with pursuing that proposal. I wouldn't want to move it forward now until I do a bit more, legal analysis of what that would be. But this special land use permit and adding conditions to it without regard to the legal license process, it would be addressing the operators one at a time, so we're not on a regional basis.
Sure.
Yeah, that was perfectly said. I just, some other tools that the Assembly has right now is that if you have a problem operator, you could attach additional restrictions to that one operation, and also, Title or Section 1050, the alcohol license, Title 10, you could place restriction or place. You could amend the regulations that would apply municipal-wide, and so to get around the equal protection issue, two options are to have justification for placing additional restrictions on one licensed operator and have findings about it, and the other option is just to treat all liquor licenses equally, like say all package stores, make them all close by midnight or something like that. those are two other options other than the area, sub-area idea that's been discussed.
So, of course, I've been involved in those discussions and thinking about it, so, regarding, grouping a bunch together, and that's why I think, okay, well, here we have a statement in here, how many within 1,000 feet? So we're implicitly saying you can have 2 men in an area, and that's kind of what these area restriction limits do. And then we say, this point 7, any significant adverse impacts will be mitigated or offset. I think the rationale in an area would be, it's not really any individual one, it's just that there's so many in this area, there's so many alternatives, it creates a magnet for lots of heavy drinkers and the problems that are associated with it. And I'm not enamored with that idea, but I'm trying to think, should it work, could it, trying to beat up. So it looks like we do have a foothold, plus we do have it downtown.
That's true. Through the chair, Mr. Weddleton, one thing that the Assembly can consider is the Assembly has denied new alcohol licenses when they, there's an application before you, and with the Shriners beverage dispensary license, that was denied by the Assembly. The Holiday gas station liquor package store on Tudor, that was denied because they didn't want to comply with Midtown's proposed additional restrictions about limiting their hours of operation, requiring more cameras, that sort of thing. So, that concentration issue is at least in our current format is about new applications and whether or not they should be granted this special land use permit or not. It's not. I don't know that we name it at existing, but it's named. Our process is built in for new applications under review.
Okay, thanks.
Thank you, Mr. Willett. Mr. Trainer.
John, you were talking about item 2 on here, 1,000 feet. Francis was right, but it was not on Tudor. It was Holiday was going into Denali Street, where Tudor and Denali Street meet at. It's that old gas station.
You're talking to Soro to go.
Right. There was one there, but there was also a Kentucky Fried Chicken. It pulled out, and they wanted to put a big package store in there. If you look right across the street, there's that Keg. Crown Jug Liquor has a big store there. We figured it was just too much concentration. As soon as people could come in, get alcohol, and pull back out the highway.
One other option through the chair, Mr. Trainee. So there used to be a liquor store across the street from Arctic Furniture. When it was Arctic Furniture, the old hockey rink, Quonset thing there. So they, I guess, I don't know if they were selling to minors or there was some sort of problem, and the license was not renewed. So that's the Assembly protested renewal of the license, and they lost their license. That's the same thing you guys did for Spirits of Alaska package store in Fairview neighborhood. So those are some other options of dealing with problem operators.
The problem is continually we have 2 different standards, one for marijuana, one for alcohol. We have absolute control on marijuana. We did that because what we learned on alcohol. We're only advisory to the board. And a lot of times if they don't want to do what they say arbitrary and capricious interaction.
Through the chair, so there's one sort of caveat to what you said, Mr. Trainee, is in old code there was no provision for readdressing existing alcohol licenses. But in the new code, I don't know if Dean got to it yet or is about to speak to it, but there's a provision that says that the Assembly, it explicitly says the Assembly can choose to revisit existing special land use permits for alcohol. And that was not in the old code. There was a process for that, but it was really cumbersome. In the new code, you can go back and readdress, and yeah. So that is to say, as it relates to the point that you made was definitely true under old code situation, but under our current code, there's one more lever that the Assembly has.
But it still has to go to the board and make a final decision.
Oh, that's true.
Thank you, Mr. Trainer. Go ahead, Mr.
And
Trainer.
I think I pulled up some code provision that I think Mr. Weddleton may be thinking of. You've seen this before, concentration and land use. This is in our standards for review governing assembly protests for the state liquor license. If there's too many in an area, concentrated in an area, we can protest issuance of a new license based on these review standards. And it's in Title 2, 31.25, but it refers to Title 21. And as Francis mentioned, those, well, it's sort of it's not stated specifically concentration, but it's implied here the impacts in surrounding neighborhood. There's so many uses in one area, of course, the negative impacts just compound themselves and so forth. So it's one of the considerations. I wanted to pull up the section, I think, because I think that's where you recall seeing it.
Go ahead.
Mr. Trainee, it's true that we don't have a municipal license for alcohol the way that we do for marijuana. But I would argue that we don't need a municipal license for alcohol the way that we do for marijuana. If you lose your special land use permit for alcohol, which the Assembly can revoke it at any time or amend it, they can't operate without their special land use permit for alcohol. So you need to have both the special land use permit for alcohol and the state's license. And so you have the same or similar controls that you have over marijuana. So the notion that, well, if the alcohol board of the state approves the license, the municipality has no control, has nothing they can do with it. That's not true. Our current code allows the Assembly to revoke the license and, revoke the special land use permit for alcohol, and then they can't operate even though they have a license, or could modify it.
Hey, Mr. Chairman.
Could you,
Chris.
is that you, Chris?
Actually, there.
Oh, hey, Eric.
That was Chris.
Go ahead.
So I want to ask sort of anyone there, but Dean to look into on that last point. Are there any restrictions on that? That is, there has been this idea put out that we can only do land usey things on land use and alcohol type conditions on an alcohol permit. And is there any limits on my ability to use my land powers, our land powers, to say, don't sell cheap vodka or don't sell shooters? And similarly, can I put on an alcohol license, we want better lighting in your parking lot and no music past midnight?
I could speak to that.
That's a pretty complicated question, but I would have to be happy to defer for instance.
Yeah, I mean, it's kind of a free-form discussion. So I think that it's kind of neater when some alcohol license restrictions that have to do with the land apply to the special land use permit for alcohol. I think Erica McConnell has said that her enforcement officers are not, well equipped to look at, is the landscaping meeting municipal requirements. But Mr. Croft, you could place restrictions on the special land use permit for alcohol that have to do with hours of operation, or even price and bottle sizes. That last one, though, I think maybe you and I have sort of talked back channel about how some of that can be tricky as time changes and new products come on the market and inflation and stuff like that.
Right.
Anything else, Mr. Croft?
No, thank you, Mr. Chairman.
Thank you. Mr. Trainee.
But Eric, I think what you run into when you try to do that is the same argument. How can you restrict what I do when you don't do the same thing to the store across the street? And that happens time after time when we take action on one, but we don't do the same thing to the store that maybe is 500 feet away. Then they'll come and complain they've been arbitrary capricious. Thanks, Eric.
Thank you, Mr. Trainee. Go ahead, Mr. Hayes.
Okay, so I guess we can continue. I wasn't sure if we answered all your questions at this point. All right. So I was comparing the license and special land use permit process throughout the timeline, and I wanted to point out, I think an important difference between the two procedures is number 4 in each in these columns here. When the decision is made, the applicant or owner, if they're unhappy with it, what do they appeal to, what happens then, and how are those costs? Who's burdened with those costs of an appeal, the risks of appeal? And there's a difference in the two. So the ABC board, they make the decision, right? They decide that they'll add the conditions the municipality requested to the license. That's their decision to add those conditions at our recommendation, right? And they have their procedures in their Alaska statutes and regulations that say the AMC board's decisions under the Administrative Procedures Act. They can first ask for an informal conference with the director of AMCO, and if that doesn't resolve, they can get a formal hearing before the administrative law judge. They're not the same as a court judge. They are a little less onerous proceedings than a superior court. And then if they don't like the decision of the administrative law judge, they can appeal to the superior court. But it's the state that's defending the state's decision in that appellate process. So for a special land use permit, we decided not to worry about adding conditions to the license and just adding conditions to the special land use permit that's under the municipal assembly's authority. Then if the owner's unhappy with that, where does it go? And our Title 21 says anything that's appealable beyond to Superior Court, some of the Superior Court rules go to Superior Court. And the way I'm reading this, and correct me if I'm wrong here, is that an assembly decision on special land use permit with conditions could be appealed to the Superior Court. And then it's an assembly decision that would be the municipal attorney defending that decision, and that would be costs. The municipal attorney incurs resources they invest in defending that decision and so forth. I mean, I've handled some administrative appeals, and I'm not worried. You can't really fight City Hall, but I can't say we're going to win every one, but it's rather a favorable standard of review because there's a reasonable basis standard. I'm going to get to the standards of review a little bit very soon, but generally, though, the risks of that appeal, litigation, and costs for it are on the municipality under a special land use permit decision. So I think that's something to take into consideration, or at least to be aware of. So the assembly modification, and this is where I'm getting to some of the standards of review. The code says the assembly has discretion to modify the conditions of the special land use permit for alcohol at any time, right? So you go through the process and do it, but you have to have findings. Those findings are you're adding modifying conditions because there's public safety concerns or negative impacts on surrounding properties. So those findings have to be based on substantial evidence, and that's the standard of review a court will apply when they're making factual findings. And that doesn't mean that you have more evidence that there's public safety concerns than evidence that there aren't. It just means that you have some evidence in the record. Maybe you have two people testifying. There's public safety concerns, and you have some documents or violations documented, and you have thousands of pages from the owner saying, no, there's no worries, we're a great operator. But you have substantial evidence because you've got that amount of evidence that will meet the standard. It doesn't have to be more evidence than the other review. So I want to be clear though, sufficient evidence in the record that reasonably supports the factual conclusions that are making, findings you're making of those two circumstances exist that warrant adding or modifying conditions. And then when you decide what conditions you're going to add to the special land use permit, the reasonable basis standard of review is going to apply to that decision. So those conditions need to relate to those findings. The conditions you're adding somehow reasonably relate to addressing the public safety concerns or the negative impacts on the community. So the reasonable basis standard of reviews kind of equates to an arbitrary, capricious, or unreasonable standard. So that's something you're familiar with. Is that correct? All right. It's generally, though, a very deferential standard. It defers to the assembly and or judgment, but it's still a standard that has to be met. And as you probably heard or see, the liquor license industry, they will fight on that standard of review, and sometimes they will win. So, anyways, the assembly initiated process, and here we're getting into the steps that it takes to get special land use permit modifications initiated by the assembly before the assembly. And as I think I mentioned, this has been in our books for a while, the new Title 21, but I haven't really seen it in use, so it's sort of a new territory for me, at least, in terms of how it proceeds. So I think that it would be, following what the code says, an application submitted to the planning director, that's the first step. And usually that's an owner who's applied for a liquor license or wants to open a bar or liquor store, but it's assembly initiating. I guess it could come from an assembly member requesting it, or committee, or the full body making a motion. We want to initiate special land use permit modification process. Send it to the clerk. The clerk's our central point of action for simple actions, right? And the clerk, Ms. Honest, would again coordinate the planning department to get that done and get that process started. And so then the rest of the steps are similar to what happens with general special land use permit. I guess the initial step is something that will work out. We've got the planning staff report that reviews the conformity, and you've seen those staff reports, and they basically have their staff analysis that has, in bold and sections in their staff report. Each of these 9 approval criteria that you've seen in the code. They analyze each of those and how this complies. They will see, I guess, for instance, I don't know if you could speak more to that in terms of a modification process, which would review, I guess, the current status of compliance with those conditions and approval criteria, as well as other requirements of Title 21, including
Yeah, they, through the chair, are, usually so you either have an existing sort of restaurant that might be bumping up an alcohol license or bumping down, or adding a new license, adding a duplicate or something like that. But then any new building or modification of an existing building usually involves a building permit. So it'll go through a building permit review, and that's divorced from this process. Is mainly about the alcohol. Whether or not it's appropriate to expand the floor area for alcohol. Will it contribute to something negative to the neighbors or whatever? Should it be approved or not? If it is approved, should there be additional stipulations or restrictions like limiting hours? The Assembly has approved licenses and stipulated a closing hour, or said no to outdoor patio service of alcohol, or the expansion of existing license. There are a lot of, I think that this forum is really a good discussion because it's good for the Assembly members to know what tools they have before they seek to change them, because there are quite a bit of powers that exist currently.
I see that I'm sorry.
No, there are no questions.
I see our time is coming short, so I'll try to speed things up here. So we've got the process. I think you've seen the public notice, the public hearing, and then the assembly action after the public hearing. I wanted to point out one thing here. Before the public hearing, developing the evidence supporting their findings. I think an assembly-initiated modification of the special land use permit, you probably don't want to start with step 1 until whoever is requesting this has a good idea of what evidence is going to support your findings. You should probably develop that first before you request initiating the application. I think that's very important because you request it, and then you end up with nothing to show for it at the hearing.
Ms. Jones.
Mr. Chair, I agree with that 100%, and I would like to let you know that Ms. Honest and I have discussed that when the Community Council can request a hearing by October 15th, they want a public hearing on that matter, but it might not come before you until January or February. What I've asked Ms. Honest to prepare a small code modification that says when the Community Council makes that request on October 15th, they have to provide the resolution and the evidence at that time. Because otherwise, you're requesting conditions that you have no evidence until they all show up. And it seems somewhat unfair to the applicant. And then you get into that arbitrary and capricious issue. So I would agree 100% with Mr. Gates. When you submit that request to the planning director, you should have at least the Community Council resolution or some other information that supports that request to modify. So if we need to work that out procedurally or make a code change, we can do that, but I think that'll make you more successful.
Thank you, and I'll just state on record that I agree with that. I hope that we move forward with that code change. Go ahead.
All right. So next we've got enforcement. So they're done. You've approved modified conditions in special use permit. You know, maybe they're to the hours or the price of $6 or what types of products are labeling or whatever. How are those enforced? And here, I guess, because it's a special land use permit, that's exclusively municipal regulation and enforcement under Title 21. Those are complaint driven. The code enforcement team generally handles those under Title 21, Chapter 21.13. And that has, for example, civil penalties of $300 per violation per day, or injunctive relief, or there's a number of other things. There's even private enforcement actions that could be had, but that I think would be code enforcement driven, complaint driven process. Chapter 1050s are general operations for alcohol businesses in municipality. Right now those are enforced by APD, and then state law has a number of regulations, some are similar to what we have, also enforced by APD and AMCO. APD enforces those in order for us to receive reimbursement of all those liquor license fees the state receives, and it's at half to the municipality. If we're enforcing state law, we're no jurisdiction. So the enforcement end of things, I guess, we see as they go when we get complaints and actual enforcement actions are taken. So, and now, just to wrap up, just got a summary of what we've covered here, and see if we have any questions. We'll open the floor if you want to add anything.
So we're pretty much out of time, but if my colleagues have any questions. Yes, Mr. Reeves.
Thank you, Mr. Chairman. You just mentioned, Dean, something about private enforcement. What exactly? I wasn't familiar that there was private enforcement.
Oh, it's in actually a few of our titles. We have that in Title 15 as well for public nuisances, for example. So any private party who's affected by violations of the Title 21 land use, it could be well, if we're talking about special land use permits for alcohol, and I can only speak theoretically, hypothetically here, someone violates, for example, their operating hours, a person, a private party could decide that they want to enforce that against the violator. They do need to contact, I believe, the split attorney. I don't want to get this wrong without reading what the code says specifically, that the split attorney or the department about their plans to do private enforcement action. And if there's no objection, they can proceed with that. It would basically be acting as private attorney general of the municipality to enforce what our code requires of the operator. I think that you probably don't see that very often because it's expensive and time consuming, and most private parties don't have that legal expertise or training and so forth to, initiate and go through the whole process. Some do and don't. So we do see that from time to time.
Thank you, Mr.
I don't know if you could elaborate on that further.
Something, Mr. Dyson?
So I'm always looking for acronyms. The drafters do really well, but on the first screen up there it said permit something BS slump. I couldn't figure out what the BS was.
Versus.
What?
Versus.
Yeah.
One versus the other.
Yeah, I thought that, but it's so inappropriate in that sentence. Good, and so on. So logic goes away. But the subject here, maybe we ought to have an active process so people who are involved and know about stuff say, there's something dumb in the code, or ambiguous, or contradictory of early stuff. And if I think it would be good for us to actively solicit that stuff. Croft is doing some of that just because he's a bright guy and cares, but I really respect that.
Thank you.
For what it's worth.
Ms. Davidson.
Oh, I was just going to ask, I'm going to run to another meeting, but Dean, would you be willing to send your presentation and the memo digitally out to all the members? Because I think both for those who weren't here and just for me to be able to reference it, that would be really useful.
I'm sure I'll probably send these tutorials to all the assembly members. I wanted to mention what else we have distributed. We have these two templates that we put together and code provisions relevant to special land use permit for alcohol, which can choose from generally. These templates we developed are taken from the planning department's templates for special land use permits. I've sort of changed it to be, the title of it is modifying conditions rather than approving special land use permit. So I think that these are templates that we probably start with at the planning department when we get there. And, but I will leave that to them. The planning department can edit and modify these as they deem necessary. I'll send these to my law.
Thank you so much. Thank you, Mr. McLaughlin, Ms. Honest, and Mr. Gates. All right, this work session is adjourned.